elimu. Sina mengi, manake vile ulivyotaja kwa kimombo, itakuwa na karibisha wageni tu na kuambia kwamba wajisikie wako nyumbani kwenye mfumo huu. Lakini wacha niseme kama asante nne. Asante ya kwanza ni yote ambao mmechukua wakati mkalipia bundles na mambo mengine kama hayo, mkakaa kwenye mkutano huu na kusikiza wataalamu wetu. Nashukuru sana kwa kufanya hivyo. Asante ya pili ni kwa wataalamu ambao wamejitokeza kuja hapa. Umewaona na mtawasikia, na watakuwa wanaongelea mambo mbalimbali kuhusiana na kitabu hiki. Na kitabu wakiongelea mambo kutoka nchi nyingine, nchi yetu, na kinaongelea swala ambalo limetatiza zaidi kutokea wakati wa ukoloni mpaka tulipopata uhuru, na tunazidi kupata hili tatizo la mashamba. Na tumepata profesa mwenyewe aliandika kitabu hiki, atakuwa hapa akituongelesha, na wataalamu kutoka sehemu mbalimbali, wasomi, Land Commission, wote watakuwa hapa, na tunafurahia kwamba tutakuwa na fursa ya kuwasikiza, na nadhani kwamba tutajifunza mengi kutokana na mazungumzo haya. Asanteni sana wataalamu. Ningependa kupeana asante ya tatu, na hiyo ya tatu ni kwa madeans wenzangu, Dean wa Moi University Law School, Dr. Omwara, na Dean wa anayesimamia chuo kikuu cha Nairobi cha Mombasa Campus, Dr. Sara Kinyanjui. Nashukuru sana manake tumeweza kuongea pamoja, tukaelewana kwamba tufanye vitu kadhaa na kadhaa pamoja. Kama mmekuwa mnafuata chuo kikuu cha Nairobi Mombasa Campus, umekuwa nafanya mambo mazuri sana pia kutuelimisha. Wamefanya mikutano kama hii tofauti, na wengine wetu tulikuwa tunaingia kwenye hiyo mikutano pia tukijifunza, na tulifika mahali tukaelewana kwamba itakuwa ni vema kama tutaweka nguvu zetu pamoja na tuweze kusoma sote pamoja ili tupeleke Kenya mbele. Ndio sisi tuko tofauti kama vyuo vikuu, tuna mambo yetu tofauti, lakini Kenya itafaidika zaidi, Afrika itafaidika zaidi iwapo tutakuja pamoja na tufanye mambo kama haya. Na leo tumeanzisha tu mkutano mmoja, tuone vile kutaenda. Tunatumai kwamba mambo yatakuwa mema tukiendelea huko mbele. Dr. Mwara pia wa Moi University pia alikuwa shaniambia kwamba ana haja sana kwamba tufanye kazi pamoja. Amenipa mawaidha mawili matatu, mojawapo limenifurahisha sana. Tuseme upande wa michezo, tuweze kucheza pamoja kama wanafunzi wa hizi shule, na tufanye vitu pamoja kama hivyo masomo pia, alafu Kenya yetu itazidi kwenda mbele. Nimefurahia sana uhusiano wa hawa wakubwa wa hizi shule, kwa kimombo nawaita madini, na nadhani kwamba tukizidi kufanya kazi pamoja, Kenya itakuwa, Afrika pia na Kenya na tuseme hata ulimwengu kwa jumla utakuwa afadhali. Wanafunzi wetu naona kwamba wataweza kufaidika na nchi zetu na watu wetu wa kawaida ambao tunashughulikia kila siku. Asante ya mwisho, naomba kumpatia Profesa Ambreena Manji. Natumai Profesa ananisikia. Manake nakumbuka nikija hapa Kabarak kama Dean, Profesa alinipigia simu akaniambia congratulations, na akaniambia yuko tayari kunipa support yote ambayo nitahitaji. Profesa akaniambia kwamba ana mawaidha kadhaa ambayo atanisaidia nayo, na akafuatilia akanipa mawaidha pale na pale jinsi ya kufanya wakati nakuwa dean, na pia akataja kwamba kuna kitu ambacho tunaweza fanya kama mfumo huu wa leo, meet the author series. Alisema kwamba itakuwa ni vyema zaidi ikiwa tunaweza kuwa tunapanga kwamba aliyeandika kitabu anakutana na wale ambao wanavisoma, na itakuwa ni fursa ya tuseme wasomi wadogo ama wachanga kuweza kufuata mawaidha ya wale ambao walienda mbele zetu na wakaandika, wakafanya utafiti na wakaandika yale mambo, na mkutano kama huo alisema utakuwa ni wa faida sana. Niliona mawaidha hayo yakiwa mazuri, na nimefurahi kwamba mwenyekiti hapa Bwana Omolo amefuatilia hili jambo na ameweza kufanya Meet the Author Series ya kwanza, na tumejumuika na universities zote hapa, na tunaomba kwamba mfumo huu uendelee ili sote tuweze kufaidika. Profesa Manji, asante sana kwa mawaidha haya. Mawaidha haya ni mazuri. Nilipofikiria mambo haya kwa makini, Manake ukiangalia usomi ama uandishi, uandishi wenyewe ni jambo la kimungu. Manake Mungu mwenyewe ndiye alianzisha kuandika. Vitabu ambavyo vinasifika zaidi ni vya kidini. Tuseme kama ni Biblia au Quran, inamaanisha kwamba Mungu anaongea kutumia maandishi. Na usomaji au uandikaji basi ni vitu ambavyo vinaheshimika zaidi. Mara nyingi waandishi wanapoenda kuandika wanafanya utafiti kwa muda mrefu sana. Ambreena alishatuambia wakati mwingine kwamba ilichukua muda mrefu sana kuandika hiki kitabu. Na wanapoandika wanatafakari, wanaongea na watu, wanasoma vitabu vingine, wanasoma historia, wanaweka kile na kile pamoja, na wanakuja na kitabu ambacho kinasaidia sana. Wanakuwa na mawaidha mazuri ambayo yanasaidia nchi ya mataifa. Na iwapo tutaweza kukutana nao, manake mara nyingi hatukutana na wanaoandika vitabu, itakuwa ni jambo nzuri sana. So bwana mwenyekiti, mimi nimefurahi kwa huo mpango, na nimefurahi kwa Profesa Manji na mawaidha haya, na kuanzisha yeye mwenyewe kutuongelesha kuhusu kitabu chake chenyewe ambacho kinahusu mashamba na zile shida ambazo tumekuwa nazo kwa mashamba kutokea wakati wa uhuru. Naomba pia vile nilivyotaja, mjisikie nyumbani, mjienjoy, tuongee, tujadiliane, na kisha tupeleke nchi yetu mbele, na tutafute kitabu kingine pia na mwandikaji mwingine na wasomi wengine, na tuweze kuendelea na mjadala huu siku za usoni. Nashukuru sana na karibuni Kabarak, UN na Moi pamoja.
Shukran Professor Ambani. Kidogo wanitatiza kwa lugha ya Kiswahili. Mimi ni mtu wenye tuna uweledi kwa lugha ya Kiingereza, kwa hivyo nitaendelea na mtindo huo. Thank you very much, Professor Ambani, for the opening remarks. A few housekeeping issues is we hope to end the event at around 2:45 p.m. East African time, give or take. Then for participants who might have any questions or comments, kindly feel free to share them through the chat function. And I also wish to alert you that we are also streaming live on Facebook at Kabarak Law School. Kindly continue engaging on this interesting topic. Of course, the land question in Kenya, which is also true for many other countries in Africa, has proved itself to be an enduring one. If you look at its history, you would go back to the pre-colonial times, and that history would indicate to you the way in which land issues and land rights have been mismanaged at different points in time. And of course, you'll be able to see writings by different authors. You could look at writings by Professor Okoth Ogendo. You could see writings by Professor Yash Palgai and many other authors, essentially trying to deal with the land question in Kenya and in Africa in general. Indeed, the land question still remains with us today, testimony of its enduring nature. At this juncture, you'll allow me to invite Ms. Ida Mwadilo. Ida Mwadilo would make a presentation on a poem whose title is Where I Stay is Sold. This poem is written by Barak Wandera in the Millennial Voices East African Poetry, published in the year 2020, which is an anthology of poems done by different young people. And you can see that the land question has truly become an intergenerational problem, that people wrote about it at the beginning of 20th century, and we still have millennials writing about it in the second millennium. Ida Mwadilo, could I hand over to you? Welcome.
Good afternoon, everyone. I hope you can hear me.
Yes, we can hear you.
All right, perfect. My name is Ms. Mwadilo, as introduced. I shall read the poem to you. I hope it enlightens the conversation. So, yes, I sold it all. The parcel of where my own stands to our fellows, our supervisor. Yes, I sold it all. Only of land where my only house stands, to set off my bills, school fees, and food bills, left unpaid by Onjom, the man who took 2 cows to my parents. Yes, he left the bills and 7 children when his ancestors summoned him to the other world. Yes, so I sold it all. The only parcel of land that the son of Ohinga left behind, for ancestral sermon that he could not reject. I had to feed his 7 clan members, who we passionately sired together like untamed wild animals, so that one day, yes, one day, they too become supervisors like my boss, maybe to buy parcels of land to sellers like us. You never know. Yes, I sold it all. My only parcel of land, where my only house stands. But if state delays to send us fruits of our sweat, or our supervisors share again our fruits, I will not move out of my sold house for the supervised family. And no one will take it from me, I swear. Lest I slaughter all my clan members in my house and myself to meet Onjong, son of Ohinga, and laughs together from teeth gnashing greed. Or I will sell our organs, kidneys, and I know my supervisor will find me ready market, since where I stay is full. Thank you, and I hope you enjoy the rest of the session.
Very much, Ms. Ida Mwadilo, for the presentation, which clearly should set the platform for our discussion today. And you'll actually note from the presentation by Professor Ambreena Manji, that she tries to look at the land question not from the narrow legal point of view. She's tried to look at it from a very broad point of view. And this presentation by Ms. Mwadilo clearly indicates that the land problem is not a legal problem. It's a problem that's bothering many other people beyond the legal fraternity. And it's only by incorporating the voice of everybody that we should be able to get a comprehensive resolution to the problems that we have. At this point in time, kindly allow me to welcome Professor Ambreena Manji to make her presentation on her book, The Struggle for Justice and Land in Kenya. I know her presentation would cover different topics that have been dealt with in the book, but mainly it will be concentrating on chapter 7 and chapter 8 of the book. And we had shared a copy of an electronic copy of the book in advance with participants. We hope that you had time to read it in good time and that you should be able to participate. Welcome, Professor Ambreena.
Thank you very much. Good afternoon, everybody. Nimekusikia Dean Ambani. Shukrani sana, samahani nikiendelea kwa Kiingereza. I want to say a huge thank you first to Kabarak Law School for their collegiality and for their support in my work. It takes a huge amount of work behind the scenes to put on an event like this. And I want you to know how much I appreciate you doing so. Very particular thanks to Omolo Joseph for all his commitment and his huge energy in doing this. Thanks also to Ida for reading a poem. It's a lovely way to mark the start of our session and a meaningful way to do so. And thanks in advance to my respondents for their generosity in being with us this afternoon. I very much hope that this will be the first of many events in the Meet the Author initiative, which I think is a really important way for our law schools to come together to create an intellectual community and to understand, to discuss each other's work. I hope that from now on, we will find ways to address each other in our own languages about our own African ideas. And with that, I'll begin my presentation. I'm going to share my screen. And very much hope that I can just move this into a slideshow now. Okay. So I'm going to speak today on the idea of the possibilities of land restitution. And what I'm going to try and do is take forward some of the ideas in chapters 7 and 8, and to build on previous lectures, which some of you might have attended, in which I speak about the themes of the book. But one of the themes that we haven't really discussed in detail in any of these lectures has been the idea of land restitution. And it's a portion of the book that I really wanted to highlight today, to take the opportunity to encourage you to engage with this idea, to read the ideas that I have presented, but also to read more widely and hopefully to take your own research and in your own scholarship. So to begin, where we have already made an intervention in lectures when we've discussed this book, we have in previous lectures talked about the idea of historical land injustice. I gave a couple of lectures on this topic. You can probably find those videos now online, or I'm happy to share them with you, in which I describe the idea, the term historical land injustice as now a critical keyword or term in the way that we talk about land. And in doing so, I'm drawing on the work of the literary theorist Raymond Williams, the Welsh literary theorist Raymond Williams, I should say, given that I'm based here in Cardiff in Wales, in which he discusses the idea of keywords. Historical land injustice is now a term that we almost take for granted, but what are the origins of this keyword or key term? Well, its early use is, if you trace it, one in which individuals were trying to give us a sense, to try to communicate a kind of nebulous idea that grievances about land had affected them, had affected a particular community or a particular territory. In other words, it was the language of citizens who were straining to find a vocabulary in which to construct their own popular knowledge of land. And in the book, I describe this as the creation of a popular archive on land. Sometimes my screen does freeze. Apologies, it does seem to have frozen now. Let's see if we can go forward. I'm going to just stop sharing a second and reset it. Okay. But we can, of course, talk about different epistemic framings of land. And in doing so, we would draw on the work of Grace Musila, who has described how ideas can often emerge in tension with each other. And she describes this as the marginalized and the powerless using or relying on different epistemic framings of stories to those framings used by the powerful. And I adopt this idea and work with it in the book to try to explain how land stories of the marginalized and the powerless use particularly different epistemic framings of of land. Similarly, in the work of the Kenyan historians, Atieno Odhiambo, David William Cohen, I find this idea of how a central task of Kenyan historians has been to forge a new history, and how one of the ways that this is possible is to invent, to assemble together, to arrange around a metaphor, and in particular the metaphor of struggle. And in the book, I use the idea of struggle as a theme that unites all of the chapters of the book to try to understand how Kenyan history has been invented and assembled, but also how it might be disassembled and reassembled in ways that we would wish to do. Once again, my screen has frozen. Apologies, this does happen every so often. I do apologize, just bear with me. Usually resolves itself. So, important to point out that we must bear in mind at all times, why is land an important topic for our attention? It almost goes without saying, but I think it's still important to stress that we recognize land as a critical factor of production, but also, and this is exceptionally important to say, as a fact of social reproduction. And I would point here to Professor Osomo's fantastic work on social reproduction theory, and in particular this essay, from which I've hugely benefited, on the connections between the sorts of concerns I have about land reform and its limits, and questions of social reproduction. And in particular, this paragraph from a recent essay by Professor Osomo really sums it up for me. So this is the idea that in the agrarian South, land has a particular significance, but also, and you'll see here italicized in my notes, African land relations and the contestations which accompany them and precipitate reform of land or land tenure need to be understood concretely in relation also to social reproduction. So what Professor Osomo is doing here is making the sort of connection which is highly original, which brings together two areas of work which you would think about as almost unrelated to each other. Social reproduction theory, what does it mean to socially reproduce a family, a community? What sorts of resources do we rely on? Productive resources, but also what are the needs that we have in order to maintain our families, to do the sort of labor that we need to spiritual work, community work, to function in agrarian societies. So the term, as I've already said, historical land injustices was first used in the elongated process of constitutional review in Kenya, and mostly you find it used and mobilized by civil society activism. Very important that the Kenya Human Rights Commission published a report very early on entitled Redress for Historical Land Injustices in Kenya. And in a way, what that meant is that it firmly entered Kenya's constitutional lexicons, and the idea of land and the idea of constitutional change became very early on harnessed to each other. So both the National Land Policy in 2009 and the 2010 Constitution used the term historical land injustice as a way to assert the connection between land and the achievement of justice in a lot of domains, not just in the land domain, but more generally in relation to different heads or different domains of justice. And similarly, the report of the Truth and Reconciliation Commission made the connection. I think it's a very good illustration of the connection between land issues and claims to justice. Although, interestingly, the term historical land injustice doesn't appear in the legislation which created the commission. The first legislative attempt to give content to the term was in the National Land Commission Act which sets out the broad contours of a definition in section 15.2. I'm not going to read that out loud, but for anyone who's looking for references, section 15.4 then sets out the different heads under which a claim alleging historical land injustices is permissible. See also, if you're looking for tracing this term and how it's evolved, the language used in the Investigation of Historical Land Injustices regulations from 2017. And importantly for my discussion today, my argument today, these regulations distinguish between historical and present land injustice. And I think what that points us to is the need to scrutinize the possible contours of this. What does historical land injustice mean, and how might it be distinguishable from present land injustice? So my aim in this lecture is really to take this idea of keywords, which I derived from reading Raymond Williams' literary theory, and to make the argument that it's a keyword that we should contest. In other words, keywords are contested or contestable. There is no necessary settled meaning in any keyword. And for this idea, I would really recommend to you an essay by Carly Katzia in the Journal of African Cultural Studies, in which she talks about how keywords, the idea of keywords is precisely that they try to discuss or debate. They're an entry point into contested meanings, not settled ones. So how do we critique our current understandings of the idea of historical land injustices? I think that what I want to suggest in this lecture is that there are complex temporalities and intertemporalities in relation to past and present land injustices. In other words, they cannot be neatly sealed off from one another. Historical land wrongs bleed into and shape our present day economy, Kenya's present day political economy. Ranisa Mawani has written very persuasively about the way in which law and legal studies, we could say, treats time. And she argues that in legal scholarship, law's time, how law's time works, has been assumed rather than actually critiqued and problematized. So she makes the idea that she offers the idea that we need to think about law's temporality, in particular in relation to colonial politics. And she's written, particularly useful for us, about constitutional time, what she calls constitutional time. And she argues that when we talk about constitutional time, we are employing the idea that there's been a kind of imagined break with the past and the promise of a better future. All of us who were involved in the inauguration of the Constitution in 2010 remember this feeling of an imagined break with the past. So the Constitution is figured in our imaginations as a moment of discontinuity and interruption between our past and our future social and political life. In other words, the Constitution somehow has this task of disjoining time. So it encourages people, it provides us with a way of vocabulary for articulating how we want to move beyond the past and overcome our individual differences to strive for a better future. But we mustn't take that idea of an imagined break without critique. It's possible to critique that idea, or to think about what work does the idea of an imagined break do in constitutional theory. So to offer some ideas then about how we might reconceptualize, if you agree with me that the task could be to reconceptualize historical land injustices, then I'm offering you some propositions. The first is that it's impossible to envisage our present day economic structure without acknowledging how that structure has been left to us, is the legacy of regimes of land ownership, which were facilitated first by a settler political economy, and then after independence, by an elite which reserved for itself access to ownership of land on a massive scale. Land wrongs in Kenya, I suggest, do not fit into a neat temporal temporal category, the sort of neat temporal category that law wants us, encourages us to try to use. So law and policy are constructed around terms like historical land injustice in neat categories in a way that misrepresents how land wrongs actually take place and how they might be addressed. So the proceeds of land wrongs, I would argue, circulate and recirculate in the economy, and current land injustices can't be understood or closed off from the past of Kenya's political economy. And I point you here, of course, inevitably to Issa Shivji's work on accumulation in an African periphery, which gives you a really powerful theoretical framework for thinking about this. So he explains how the enclaves of super exploitation of the colonial period, which were about racial privilege, were changed after independence. They were no longer racialized, but the fundamental relations of production and accumulation didn't change. So what Shivji argues is that racial privileges were replaced by ethnic preferences underwritten by a neo-colonial state, and a deeply conservative structure was therefore bequeathed to Kenyan politics. Radical change became impossible in a neo-colonial state with an ethnicized land question and with a Gini coefficient, which is still hugely problematic. So understanding the continuities in the perpetuation of land injustices is critical. So in other words, and I would put this as a proposition to you, it's important to avoid a model of historical land injustices, which is founded on the idea that somehow historical land injustice is an exceptional thing. Instead, we should recognize that there's nothing past about historical land injustice. This requires us to complicate law's time, the linearity of law's time. The political economy of the present day is deeply imbricated with land wrongs. Land injustices, we could say, are sedimented in the political economy. And I draw here in the book on David Harvey, who of course informs Shivji's work as well, to argue that the normal economy, what we describe as the normal economy in Kenya, is founded on the idea of accumulation by dispossession, which Harvey develops in his book, Drawing on Rosa Luxemburg. So it's not possible to isolate present and past historical land injustices. And it's not possible to understand our political economy absent an understanding of how the normal and the supposedly abnormal, you know, we talk about corruption, land grabbing, etc., how these two things are part of a continuum. They're codependent on each other. And here we can draw on Patrick Wolf's work to suggest that historical land injustices are structures. They are not events. Just as colonialism was not an event, it created a structure. So historical land injustices are structures, not events. And a nuanced and responsive analysis of Kenyan land struggles would take seriously those structural consequences of land wrongs, rather than seeing them as something that has taken place in the past that might leak a little bit into the present day. See them as necessary, as structuring the present day. So, as I've said, land wrongs at Kenya don't admit of this neat temporal categorization that law loves. Law loves to work with neat temporalities. Instead, land wrongs circulate and recirculate in the wider economy. They shape the country's political economy, then they feed back into the land sector. So on this reading, the reports of commissions of inquiry, and all of us in this room will know the ones I'm referring to. I'm thinking of the Truth, Justice and Reconciliation Commission report, the Dungu report, etc. These are not, on my reading, these are not just land reports. These are actually important archives of the entire political economy. They tell you who owns what, who controls what, and how. So to come now to the idea of land restitution, on which I build out of the idea of historical land injustice in my book. Both the Kenya Land Alliance and the Kenya Human Rights Commission have in the past called for national land restitution laws to provide an architecture and an institutional context in order for Kenya to start to take seriously long-standing land grievances. So we have to discuss, as I do in my book, land restitution. We must discuss it as a topic because it's part of the context of a wider transitional justice debate. And a number of times we've heard calls for Kenyans to be afforded opportunities for legal redress of historical land injustices by the mechanism of restitution. And Paul Siaga has shown in his work that the legal framework for restitution at the moment remains weak, and I would highly commend his 2015 working paper essay to you for insights into that idea that it's possible to work with this mechanism, but at present we can't because the legal framework for restitution remains remarkably weak. So, given that this framework remains weak, why am I discussing it here? Well, I think, and I suggest this in the book, we should try to imagine other possibilities than the one presently before us. In other words, a restitution law, even a restitution debate, may not be possible or achievable anytime soon. But even by discussing it, we begin to unsettle the elite consensus on land in Kenya. And we challenge a regime which is rooted in neoliberal models, which are undergirded by liberal legalism, by the idea that you can make all things right by mobilizing the law. So it may not be possible, it may not be realistic even to talk about restitution. And I'm very interested to hear from the respondents about whether they think that's a fair assessment. But even if it's not possible, it's still important to unsettle a consensus, unsettle our received ideas by talking about it. And I would highly recommend to you in this regard that you read the South African debate on restitution, which I think is highly suggestive. It may not be directly relevant to us, but it's suggestive of the sorts of discussions we could start to have. And I would particularly recommend Ru's work on land restitution. So we could look at the South African Restitution Act, and Ru makes the argument that I think is really important, that despite a very well-intentioned framework for land restitution, in fact, that framework has largely failed to address what he describes as the moral harms caused during the forced removals of the apartheid period. And we can learn a lot from this as we start to have a debate in Kenya about restitution. What does the restitution legal framework aim to do? And how might it address not just structural or, actual harms? How might it also encompass or recognize the moral harms caused by past historical injustices, or, for example, dispossessions and removals? Ru recognizes, of course, that the South African framework was the outcome of constrained policy choices. The compromise was reached that the restitution of land rights would not detract from the new legal order's overarching commitment to the protection of private property. And here, of course, as Kenyans, we'll recognize immediately that that's also the constrained circumstance in which we are living. For Ru, land restitution schemes were conceived in very legalistic terms, about being about the reversal of a particular set of unjust transfers. So rather than thinking about how does restitution provide redress for deep social harms, psychological harms, embodied in apartheid land law, instead of thinking about that, the restitution framework and the schemes that followed it are aiming at simply a kind of simplistic idea that you can reverse these wrongs. And similarly, in Cheryl Walker's work on land claims in South Africa, she argues that there's been a lack of attention by the state to the symbolic, cultural, psychological elements of restitution. So only minimal attention has been given to what she describes as non-material issues. I think that's a lovely way to put it. So yes, material issues, the restitution of land, but also non-material issues around memory and identity and public recognition. And here I might add social reproduction, the loss of a community's resources for continuing as a community, the deprivation of family life, the deprivation of spiritual sites, of meaningful landscape, all of those things deserve recognition, symbolic elements of restitution in Walker's words. And I would point you here also to Liz Alden Wiley's work, in which she assesses the sorts of outcomes that might be expected, given that in Kenya we have the possibility of communal land-related historical land injustices being expressed or addressed to the National Land Commission. Liz Alden Wiley argues that this is a mechanism that might provide for the recognition of collective title. It might be a useful way to construct, to do work to transfer land, for example, back to community ownership. And she says this is most likely to be a useful mechanism where the claimed lands are currently defined as unallocated or unoccupied public land. So she's just giving us a little mechanism or a possibility of a mechanism that we can work with. But she says, thus far, the state's approach in Kenya has been to restore, that even where it's feasible to restore land to a community, they have instead preferred to carry out evictions and provide compensation. So the complainants achieve compensation, yes, arguably some material improvement, but it completely fails to address these other kinds of spiritual harms and long-running community harms that we've been alluding to. So in other words, it's important to say that in Kenya, it's not the lack of a legal mechanism that we're suffering from, as Alden Wiley says, but in fact, there's real political resistance to the idea of restitution. And it is that that's preventing action. So of course, we all know that our constitutional settlement arrived at by 2010 was the result of significant compromises. Kenya embedded a provision protecting private property in the constitution, and on one reading, the existence of a constitutional guarantee of this sort, alongside a provision compelling the investigation and resolution of historical land injustices, creates a contradiction. How do you reconcile these two things? And this is a good example of what John Harbison has described as Kenya's constitution making possibly conflicting promises to itself. And that's a prime example of a conflicting promise to ourselves. On the one hand, guarantee private property, on the other, deal with historical land injustice. How do you do both? So only by adopting the narrowest idea, the narrowest understanding of historical land injustice, only by construing that term in the narrowest possible way can this contradiction be resolved. So in other words, I describe in my book a difference between lawyers' historical land injustice and people's historical land injustice. The current deeply conservative structure of Kenya's politics shields those who unjustly acquired land from demands for redistribution and restoration, except in the most glaring case. In other words, we still think of historical land injustice as an exceptional matter. And Omola Joseph kindly referred to this at the beginning in his introduction, and also did us the honor of arranging a poetry reading in order precisely to make this point, that in trying to understand some of the complex land issues with which we're grappling, no one disciplinary perspective is adequate. In other words, we need to go beyond a formal analysis of the law. Guy and McCausland in their 1970 text explain this approach in their landmark work, and they highlight both the fact that we should be aware of how law was actually used in the scramble for Africa. So it's not necessarily a solution or a tool for redress. It was used, law was actively used in colonial dispossession, to achieve colonial dispossession, but also a recognition that we need to go beyond formal analyses of the law. So they, in this text, they do beautiful, beautiful work to present us with formal analyses of the law, but they also say go beyond that formal analysis and draw on different interdisciplinary, different disciplines in order to understand the land question. And this is something that I try to do in the book. I try to draw on multidisciplinary work, and in work that I've been doing more recently, I've been similarly trying to do that. So to think about where can we draw, what other disciplines can we draw on to think about ideas such as restitution. And work that I want to do when I can is work on restitution, the idea of restitution in relation, for example, to cultural objects looted during the colonial period. So this book, the British Museum, with its wonderful title, tells you everything you need to know about the idea of confronting that period and the dispossession that occurred in relation to cultural objects. And I'm thinking a little bit about how might this work be useful to us in thinking about land restitution. I highly commend that text to you. So might we draw on debates in museum studies to think about the politics of restitution? So just as colleagues in museum studies are having debates about artifacts and the way that they were looted and what it would mean for those objects to be repatriated, and how do we get momentum behind a campaign to do so, in the same way we can think about how do we get momentum behind the idea of land restitution and the debate on land restitution. And I truly believe that we should, colleagues in different disciplines should be talking about that and hearing similarities, echoes, and harnessing their work to each other to try to mobilize what I think are really powerful ideas together. And in doing that, I want to just end by reminding us that what we're speaking of when we speak about restitution, and this is a social reproduction point, what we're talking about in the Hawaii State Commission on the Status of Women put this very nicely when they talked post-COVID. They were talking about post-COVID recovery. They talk about this idea of recovery, but recovery is not just about a responsive recovery. It's also about how do we repair? How do we repair historic harms? How do we take seriously intergenerational trauma and the different ways in which that has played out? So how do we take seriously the harms of patriarchy? How do we take seriously the harms of colonialism? And how do we talk about repair from those harms? So just to start to wrap up, my book is concerned with land as a both in material terms, but also at the level of ideas. It's concerned with the idea of domination at the level of ideas. So how do certain ideas about land come to dominate? And of course, a reminder that this is important because land is a critical factor, both of production and of social reproduction. The term land reform has a long history in Kenya, but in different eras, it's been deployed as meaning as the idea of those who can govern its meaning. More insurgent ideas of land reform, when they've been asserted, they've been extinguished. And that's really important to remember. It's not that we are having to develop new ideas. Those notions of land reform or land redistribution or land restitution were always there, and they were insurgent notions, but they were extinguished. We must remember that. And in their place, hegemonic notions of land that valorize individual tenure, private ownership, the idea of improvement of land, they have not lost their hold. They are the powerful dominant ideas. And I'll just, by way of saying that, remind us of some of the writers who we can turn to think about insurgent ideas in Kenyan history. The intellectual history of these insurgent ideas has yet to be written. And I'll leave it there. Asanteni sana. Diolch.
Thank you very much, Professor Ambreena Manji. I have read your book a number of times, and listening to you make your presentation today, the ideas still remain very fresh, even as you talk about them today. And one of the biggest takeaways from this series of the Meet the Author series is that I want to mention that Professor Ambreena's book is quite a short one at just 208 pages. But as you go through it, you'd admit that the book opens doors to many other resources that would help anybody who's interested in land injustices in Kenya and in Africa in general. And the approach that she takes is multidisciplinary, so it's not a book that would be restricted to only lawyers. It's a book that anybody would take and be able to really enjoy. Thank you very much, Professor Ambreena. At this point in time, allow me to welcome our first respondent. Our first respondent is Mr. Gershom Otachi. Mr. Gershom Otachi is the chairperson, the National Land Commission. Mr. Otachi is a graduate of the University of Nairobi, and he was admitted to the bar in the year 1990. He has been in legal practice as an advocate for 29 years, appearing before different levels of courts, tribunals, practicing in civil litigation, criminal litigation, land and property. He has also simultaneously practiced law in international courts for a period of over 20 years, and he has served as the chairman of two state corporations, that's Policyholders Compensation Fund and Geothermal Development Company, for a total of 6 years. He is a member of the Law Society of Kenya, East African Law Society, International Commission of Jurists, Kenya chapter, International Criminal Bar, International Association of Defense Lawyers, Association of Defense Lawyers at UNICTR, of which he was vice chairman for 6 years and is on the ICC list of councils. Mr. Otachi currently, as I mentioned, is the chairperson of the Forum of Constitutional Commission and holders of independent offices. Mr. Otachi, welcome.
Thank you very much, and a very good afternoon to everyone. And a special greetings to Ms. Ambreena Manji, and thank you very much for the very eloquent and very useful explanation of background to the book. I must first of all, I must start with a confession that I've actually not read the book thoroughly. I have the book, I bought it, but I browsed through it. But now with this presentation, I almost certainly would have to read through it thoroughly over this weekend to start with. So I appreciate the presentation that gets us to understand that we need to look at historical land injustices and by getting beyond the law and, so to speak, and focusing on the spirit and philosophy behind it. But having said that, I think on my part as chair of National Commission, I would probably focus on our mandate, which really also is a focus on the mandate as enshrined in the law. And then I'll quickly point out how far we have come with the exercise of that mandate and the challenges that we face. I know I have just a few minutes, so I'll try to be as concise as I possibly can. Now, the concept of the historical land injustices, as we know it now, was first dealt with in the National Land Policy 2009, where in paragraph 178 of the policy, historical land injustices were defined as grievances which stretch back to colonial times. And so the sources of these grievances include land adjudication and registration laws and processes, and treaties and agreements between local communities and the British, amongst others. So there was a recommendation in the national policy that these historical land injustices should be looked at, and a mechanism should be established for that. And that is the basis upon which in the new Constitution of 2010, the National Commission was established, and one of the mandates under Article 67, Sub-Article 2, was to provide that the NLC shall initiate investigations on its own initiative or on a complaint into present or historical land injustices and recommend appropriate redress. Now, the statutory framework now for that constitutional provision is found in section 15 of the National Land Commission Act, which again, of course, defines historical land injustice as captured in the Constitution. But then that section proceeds to provide various parameters that should be established for purposes of inquiring into historical land injustices. And some of those parameters, I would say, are contentious to the extent that the Constitution provided a broad mandate, but the section appears to an extent to limit some of those, to provide some limits. So historical land injustice is defined as a grievance which was occasioned by a violation of rights in land on the basis of any law, policy, declaration, administrative practice, treaty, or agreement that resulted in displacement from their habitual place of residence. So there's the aspect of actual displacement from the habitual place of residence, and that occurred between June 1985, when Kenya became a protectorate, and 27th of August 2010. Of course, there's again a contention as to whether we should have those limits, those precise dates in terms of historical land injustice, but that's what the section provides. The other limitation is that the claim has not or is not capable of being addressed through the ordinary court system. If the claim contradicts a law that was in force at the time, and then it's brought within 5 years from the date of commencement of this act. Now, that time frame, again, has been the subject of contention. It happens that that 5 years following an amendment to the act, the 5 years actually lapsed September of last year. So a claim of alleging historical land injustice, there is a broad definition again of the various categories of what constitutes historical land injustice: colonial occupation, independence struggle, pre-independence treaty or agreement between a community and the local government, so that what gave rise to that injustice is based on that. There is what is described as development-induced displacement, for which no adequate compensation was provided, inadequate land adjudication process or resettlement scheme, politically motivated or conflict-based eviction, and natural disasters. Now, moving now from the broad definition of historical land injustice, I think this is where the debate gets interesting, because following the presentation by Ms. Manji, moving from establishing that there is an injustice onto the remedy is where, in my view, there is a considerable challenge. Because it's not difficult to establish that from the set of facts that indeed there is an injustice. But then what is the remedy? So I have listened carefully to the very interesting discussion on the issue of restitution. Let me start with the dictionary definition of restitution: the restoration of something lost or stolen to its proper owner, or recompense for injury or loss. And the synonyms are to return, to hand back, to replace, to surrender, and so on and so forth. So when it comes to restitution, and you're talking about some of these colonial injustices, or injustices that go back over 100 years or decades, the extent to which there can be restitution in the physical sense, because I've listened to the interesting discussion about restitution in the broadest sense. But now talking about restitution in the physical sense, and I think that's what the law contemplates, there is a question of to what extent can you have restitution? As test cases, I think we have a number of decisions by this commission that are now the subject of court cases, and we are yet to see how that, what the final decisions will be of the courts. Now, a classic case in point is the determination regarding a complaint by the Talai community alongside the two counties where they reside, the Talai and the Kipsigis communities, and then the counties Kericho and Bomet alongside that presented these claims. And the recommendations were considerably far-reaching in terms of what should happen. And one of the recommendations was that there should be non-renewal of leases once they expire. And there are also recommendations about the various multinationals occupying a vast amount of land in the two counties to now hold those lands under commercial leases under commercial terms. So and these are some of the recommendations that are the subject of the court decision. And there were similar recommendations with regard to Del Monte in Kiambu, not as far-reaching in terms of the recommendations, but there were recommendations about once the leases expire, a certain portion of the land then should revert back to the community. So the aspect of restitution, I think, is one that we should have a continuous debate on, and to what extent it's possible and how easy it would be. The other remedies are compensation, if it's not possible to restore the land, resettlement, rehabilitation through provision of social infrastructure, affirmative action programs for marginalized groups and communities, orders for revocation and reallocation of the land, amongst several other recommendations that the Commission can make. Now, what should be noted with regards to what it is in terms of the mandate of the Commission, how far it goes, is that the Commission only makes recommendations. Upon a determination, it makes recommendations, and those recommendations are supposed to be enforced by some other agencies. The law requires that any authority mandated to act under the redress recommended is required to do so within 3 years. Now, I think those 3 years are not really realistic from the experience that we've had so far. In fact, the truth of the matter is that out of over 100 recommendations made so far, I think there are a paltry 10 or so that one could say there has been action upon. Now, in terms of the numbers of claims that have been presented to the Commission, now, just before the advent of COVID, we had in the region of about 600 claims, and out of which about a third had been processed. Then we had one of the challenges we've had is that the COVID pandemic totally slowed the whole process of hearings, investigations and hearings, because historical land injustice by their very nature would require field visits and engagement with communities most of the time. And that's one of the challenges that we have faced. Now, because there was also the time limit that was imposed by the statute, and that time lapsed in September of last year, 21st September 2021, when the commission notified the public that the time period was about to expire, there was an avalanche of claims that were filed. And now we have in the excess of 2,000 historical land injustice claims. But I must hasten to add that the numbers may be misleading as to the nature of the claims. The numbers, what the numbers reflect is, it is how the claims are fashioned or titled. So a mwananchi would consider whatever claim they have that they have not tried to resolve in one way or the other as a historical land injustice claim, and style it as that and file it with us. But as we go through the issue, the aspect of admissibility, it turns out that it's not as many as that number that actually qualifies as historical land injustice claims. But arriving at that decision itself is a process as to whether it's a historical land injustice claim or not. Now, what are the challenges? I'm just trying to be brief because I was given about 10 minutes. So what are the challenges that we have faced so far in this the exercise of this mandate? One is the issue of recommendations and sorry, the implementation. As I've pointed out, the law provides for a 3-year period within which recommendations should be implemented. In practice, there are challenges with those recommendations being implemented. I have pointed out that there are a number of matters in which the parties that are affected by the recommendations have gone to court to challenge the recommendations. And that is partly because the recommendations, when they have a bearing on other interested parties in the land, they would obviously want to challenge that instead of yielding to the recommendations. Then there's the aspect of the non-responsiveness by the state agencies or authorities that are asked to implement the recommendations. We have had the most serious challenge, I would say, really is one of resources, because being able to conduct investigations and conduct the hearings and be thorough enough, it's very, very involving in terms of resources, in terms of field visits, in terms of human resource capacity. And that's one of the things that has slowed down and would slow down the activities around investigations on historical land injustices. So what we have tried to do in the recent past is to be as innovative as possible in trying to fast track the processing and hearing of these HLI matters. And one of the ways we are doing that is the use of virtual sessions, such as this one now, Zoom and so on, when it's possible. It is a bit challenging, obviously, for a lot of the claimants who are very ordinary villagers who may not be able to, who are not very, very savvy in terms of the use of technology. And sometimes it's not very, very convenient in dealing with these matters through virtual sessions. But to the extent possible, we try to do the preliminary issues in terms of agreeing on the way forward, wherever it's possible through virtual sessions. And then, of course, well, I think that, yeah, that really, then of course, we also try and see to what extent we can use, the ideal scenario is to have commissioners, visit a particular area and listen to the parties But because of the large number and the resource aspect, we also try and see to what extent we use our staff on the ground to collect, preliminary, information, and that helps us, we sieve through, and then it helps us to move faster when we are processing that. So I think that really, in summary, because I was asked to make a very brief comment, that in summary is what I want to say about what we do as a commission. But as going back to what I said at the beginning, yes, so as I said at the beginning, it's an interesting debate as to the issue of restitution. As I said, it's one thing to collect the facts and confirm that there is a wrong, and moving on now to the remedy. Once you have established the wrong and moving on to the remedy, and that aspect, particularly of restitution, I think it's a subject that we must keep on addressing. And that aspect of implementation, because as we move along and come up with recommendations, if we come up with recommendations that are not capable of implementation, or where there is either reluctance to implement or there's impossibility in terms of implementation, then it means we must then relook at the whole concept of the historical learning justice and that mandate and what it is that was intended to be achieved. Now, one of the questions that has been posed is whether the hearings are administrative or quasi-judicial. The hearings are actually quasi-judicial. This is one of the quasi-judicial functions that the Commission exercises. It's not an administrative process. It's a quasi-judicial process. Let me also add that for a country where the legal system, as we know it, is really primarily adversarial, where you have party A claiming against party B. Sometimes when you're engaging even with the lawyers, issues arise as to what we should be doing and how we should be proceeding. But it should be appreciated that this process is actually more of an inquisitorial process or investigative process, which is more of the system that is found in continental Europe, as opposed to what we are used to in the Anglo-Saxon system of justice. But then the two are also combined, because ultimately, for instance, when the matters are presented before the courts and their challenges, and there have been similar a number of challenges of this nature before the courts, the courts make it clear that all parties that might be affected in one way or the other with a recommendation should be given the opportunity to be heard. So we always want to try and ensure that we have looked at all all the aspects that ensure there is fairness in terms of providing opportunity to all the parties before arriving at a decision. So those are my my brief remarks. And once again, thank you very much, Ms. Manji, for the excellent presentation. Thank you.
Thank you very much, Mr. Otachi, for sparing time to be with us today. And thank you very much for the presentation again. I'm sure many people have been looking for this opportunity to be able to hear directly from the National Land Commission on the way in which you've been able to carry out your mandate on historical land injustices. And I hope that these engagements then could actually go beyond the event today. And we also hope that you'll be able to spare time to continue staying in the event till the end of it, so that in case there are any comments that you might be called upon to respond to, then you could help with those. Thank you very much. Our second respondent is Professor Lynn Osome. Professor Lynn Osome is an educator and senior researcher with specialization in the fields of feminist political economy and feminist political theory, and research interest in gendered labor, land, and agrarian questions, the modern state, and the political economy of gendered violence. She is an associate professor of political studies at Moi University, and previously taught at Makerere Institute of Social Research, that's Makerere University, where she was a senior research fellow, and at Yale University, where she was a visiting presidential professor. She is the author of Gender, Ethnicity, and Violence in Kenya's Transition to Democracy, States of Violence 2018, and co-editor of the volume Labor Questions in the Global South, published in 2021. She is an editorial board member of Agrarian South, Journal of Political Economy, co-editor of the Journal of Contemporary African Studies, advisory board member of Feminist Africa, and serves on several boards, including the International Association for Feminist Economics and the Council for the Development of Social Science Research in Africa. Welcome, Professor Osome.
Thank you, Professor Molo. Can you hear me?
Yes, we can hear you very well.
Okay, thanks. Thanks for this invitation to discuss Professor Manji's, I think, really important work. It's an honor because your work, Ambreena, continues to inspire my own. So I'm going to look at this primarily from the vantage point, or discuss the book from the vantage point of my own critiques, which have been grounded in political economy, and as Ambreena mentioned in her presentation, on the question of social reproduction. So how do we think about land structurally, not just in productivist terms, but also in terms of the, the social and economic relevance it holds in this contemporary period. And I think, as she rightly shows in the book, these are questions we have to understand from a historical lens, because the colonial legacies that are described in this book really determine the question of justice. I think she's very right in pointing that out. So one of the primary questions which the book is grappling with is whether we can envision a more progressive role for the law. And in this kind of envisioning, she's really talking about, can the law itself be envisioned in ways that are grounded in existing social relations to land, and therefore promote the objective of supporting human well-being, rather than sort of the neo-colonial and very neoliberal productivist focus on land. Land as store of value, property, and so on, which still drives the much of the mainstream literature on land and agrarian question. And I think this question can be extended to highlight the problems which become visible when we turn our attention to the realities in the global South, what we might think of as the agrarian South. And the at least two attendant problems that we are sitting with here. One is the question of, or the problem of surplus labor. And the other one is the problem of semi-proletarianized labor, labor that strides both the wage economy and the subsistence or agrarian economy. And for these two groups, especially, land constitutes a core basis of survival and of social reproduction. And I think the book tries to explore this in a number of ways. Firstly, it rightly points out that Kenya's unresolved land question, which is a colonial inheritance, as the previous speaker also said, this unresolved land question raises significant questions that are definitive of existing political cleavages articulated in, and these cleavages are articulated in today's political economy regarding who should have access to land, where should they have this access to land, and on what terms should they access land. And these questions contain in them additional questions regarding gendered labor. And by gendered labor, I mean who it is that works the land, both productively and reproductively. It also contains an ethnic question, which is itself a legacy of the mode of colonial rule. And this, of course, this ethnic question remains central to our national question. And we can think of it primarily as being about the special organization of historical claims to land. And therefore, in this sense, I think it's also very concerned with the question of democratization. In other words, when you think of the post-independence period, there were two questions we were sitting with. One was the imperative to deracialize, and not just to deracialize the populace, but also to deracialize land ownership. I think the only country on the continent that has been able to achieve that to a large extent is Zimbabwe, at least in the post-Cold War period. This deracialization of land. But the other question that we were sitting with was de-ethnicization. These were the two primary questions that were posed to democracy, to democratization, and we still sit with both. And I think the other question, of course, that is raised, and the book raises, is the question of citizenship and legibility to the law. In other words, whose claims to land are considered legitimate, right? And the exploration of these questions from the historical vantage point of the colonial political economy, I think illustrates a particular difficulty that is at the core of the, sort of liberal individualism that is embedded in private ownership of land, which is that the individual subject of the law seems to be at permanent odds with the group subjectivities through which historical land claims are expressed. Remember, the colonial state did not, the bifurcation of the state between a civilized realm, urban realm, and a sort of traditional realm where the natives were confined, meant that individuality itself was not accorded to natives, right? So even in the post-colonial period, we have to still, ethnicity, gender, class are group subjectivities, but we have an approach that remains very embedded in a liberal kind of logic with the private ownership of land. So land itself as a communal basis of social reproduction is not easily reconcilable with this liberal individual basis of property rights. And I think the book explores this in different ways. And I think a related point which the book addresses is the fact that land that is held under communal tenure continues to represent, for the neo-colonial elite, nothing more than a reserve of land for accumulation, to grab, this large-scale accumulation that is happening both by local elites and global elites. So the residents of those these lands, these communal lands, are seen as nothing more than a reservoir of cheap labor. Seen, the language of squatters and so on. And this also is an enduring legacy of colonial land holding patterns. And as Ambreena shows in this book, it justifies a more radical approach to the land question in Kenya. So similar to the colonial, the way we've tried to understand the colonial political economy, we also need to understand this ongoing and contemporary large-scale accumulation of land, and understand it not merely as the dispossession of land resources, but it is also primarily the dispossession of working people, right? So in thinking about this struggle between capital and working people, in between that space is a regime of gendered labor and a question of social reproduction, which is how do people survive, go about their day-to-day sustenance. Whether, we know the realms that support this is wages or petty commodity production, but in the global South, in the agrarian South, our countries are still largely agrarian, most of the continent. We can't think of this question of social reproduction without thinking of land. And so social reproduction itself has to be central to how we understand and articulate questions of land justice. And I think the book traces some key debates and raises some important questions in this regard. And one question that it asks is whether we have placed too much faith in law and in legal change, including in new institutions. In other words, I think it gives a serious consideration of the limits of the law. And by this, I'm talking mainly of those earlier sort of liberal interpretations that I was talking about. And in this regard, the book asks whether strong land institutions were perhaps the wrong answer to the right question. I found this very interesting in how it's posed. And at the core of this question is the struggle between primarily an institutionalist approach to land, which is technical, procedural, and an approach that is grounded in the political economy and concerned concretely with the question of historical justice. And I think the book locates itself firmly in the latter, in the political economy. And there's a deeply philosophical basis to this question. Remember, the idea of justice itself is actually built on, you can't express an idea of justice in a system which you think is unjust. So the idea of justice itself is built upon the presumption that the present system is just. And therefore, people reasonably believe that our various claims to land are legitimate, that they should be expressed. But the land question in Kenya has not managed to shed the legacies of colonialism. And that system, as we know it, the colonial system was unjust. This is the primary kind of problem we are sitting with. And therefore, not only does doing nothing, if we don't do anything, if we do nothing, what we are basically doing is maintaining this injustice, that colonial injustice. But it also becomes imperative to reconstitute the very, we have to do something, and we have to reconstitute the basis and the meaning of justice to the colonized. And I think this philosophical question seems to be central to this book, I think in a very significant way, just posing the question of what is justice? What is justice? How do we claim it at the back while still riding on the legacy of a fundamentally unjust system, the colonial system? So the mode of colonial rule and the stabilization of the colonial political economy, which the book explores, I think also highlights the social character of the human labors that in turn shape land relations. And Ambreena talked very well about this in her introduction. In other words, much more than merely an economic factor, land is also a fundamental expression of social relations. And it is here where we have to think, or we can think concretely about gendered labor. It's a central lens through which we understand these social relations to land. And much of the literature establishes the link between colonial control over communal land and the control of the peasantry as the basis of the stabilization of indirect rule. In other words, the role of women, the role of gendered labor more broadly in the stabilization of native rule. Remember the primary question that colonists were sitting with was the native question, which was how does a small minority of white people govern a majority Black population? And this question has particularly been explored from a very, not a narrow lens, but the gendered question, what we might think of as the condition of possibility of the stabilization of the colonial political economy, which remember was based on a migrant labor regime that presupposed a sort of urban reproductive realm that subsidized the below, the sort of very minimal wages that African men were being paid. So this is a glaring omission, because even though women were not the subject proper of colonial rule, but the appropriation and exploitation of their productive labor and the reproductive labor towards reproducing the settler colonial political economy actually functioned to ensure that women constituted a crucial possibility of colonial rule. And this colonial migrant regime presumed, as I've said, a rural, tribalized, gender domain of reproductive labor that would ensure the survival of the urban migrant labor force in the absence of a living wage. So there is need for us to understand these mechanisms, the mechanisms of colonial rule, not only legislatively. Thank you for that. So there's need, we have to understand these mechanisms of colonial rule, not only politically and legislatively in relation to, the bifurcation of the state, which was a political response to the native question, but we also have to understand the mechanisms of colonial rule with regard to the structural dynamics which facilitated the stabilization of the bifurcated domains of rule. In other words, the political question and the sort of economic question, the structural question was central to how we understand colonialism. And again, I think one of this book's strengths is that it tries again and again to return us to that. In other words, the spectrum of social relations to land, which the settler political economy produced, include ethnicity, included class, included gender. You know, this fragmentation of native populations in these communal enclaves actually invariably also then produced or reproduced inequalities on the basis of gender and ethnicity, class, and so on. And these, I mentioned this because these have been the basis of, you know, they become very highly contested basis of land contestations in the post-colonial state. We cannot understand the land question, the land contestations without a concrete understanding of the articulation of the ethnic question, of class. And we insist as feminist economists that we have to understand also the question of gendered labor and its expression in processes of social reproduction. So these identitarian questions remain unresolved in the post-colonial state. And I think, as the book rightly points out, these questions must constitute our inquiries into the post-colonial land question and into democratization. Any effort to address these inequalities, whether through land restitution, redistribution, must address these inequalities, which, and you know, these inequalities are actually deeply embedded in the existing social relations to land. Another, and I'm about to finish, this is just the last point I'm making. Another significant problem, which the book highlights, is the turn in post-colonial land policy towards private tenure and the ongoing destruction of the commons and of communal lands. And you know, I think Ambreena is showing very clearly that this is likely to have and is having devastating impacts, especially on rural livelihoods, but also increasingly urban livelihoods. You know, the land question is, in South Africa, for example, when we see the struggles of the, you know, around housing, the sort of land occupations, they are really articulating a historical land question, and we see it more and more here too. This is a core legacy of settler colonialism. Am I muted? And so on. So this is because at present, most working class households cannot survive on wages alone. Most working class households are dependent to some extent on actually a combination of wages, subsistence agriculture, and petty commodity production. We saw this very clearly during the hard lockdowns in the pandemic. And I was very struck by a picture which appeared in one of the dailies. I can't remember whether it was the Standard or the Nation, where we saw public transport buses, you know, buses that usually transport passengers, were transporting food from rural areas to the urban areas, whether it was to Kisumu or Mombasa or to Nairobi. And this was not food for sale. This was families, rural families sending food for subsistence to their urban counterparts. And so this articulation, I mean, the idea is that very few households can now survive on wages alone. A lot of people are not being paid, majority of our people are not being paid living wages. So most households, most working class households depend on wages, they depend on subsistence agriculture, they depend on commodity, petty commodity production. And these are, this articulation, you know, the gendered labor that is embedded in all three processes connects them, which is the topic for a longer discussion, not here because of time. But in agrarian contexts such as ours, all three of these laboring classes now depend on some kind of access to land and landed resources. So the problem of livelihood and the survival of immiserated working people cannot concretely be addressed without serious attention to the political question of land redistribution. And you know, it is also the case that under the current conditions of neoliberal capitalism, we have economies, we hear that talk about jobless growth, but we have economies that are growing without jobs. You know, there's actually a massive attrition of labor daily being expended from industry, being expended from manufacturing. In some places, we're talking about deindustrialization. And the question, of course, we are faced with is, what is the fate of these armies of reserve armies of labor, which are no longer useful to capital? What happens to these people? How are they surviving? Who is bearing the burden of reproducing and sustaining them in the absence of stable wages? So in the third world, in our agrarian context, the centrality of land for subsistence cannot be sidestepped in responding to the question of land justice, right? So just to end, you know, these ongoing struggles, what we see as ongoing struggles are not just a contest over rights to land. People are not just looking for property. In a very real sense, they are symbolic of the deep economic and social distress in which millions of households find themselves. And this book, I think, tries to make this point through and through. We have to retain focus on this. And I thank Ambreena for her commitment to raising these debates and engaging these questions, which actually remain quite marginalized, even in some of the political, in some of the more progressive literature in land and agrarian studies. And I'll stop there. I'm sure I've overshot my time by a bit.
Thank you very much, Professor Masome, once more, and thank you for highlighting the gender aspects to land injustices. Allow me to apologize. I see we are running behind schedule. We'll try to push the remaining part of the event as fast as we could. The discussions have been very illuminating and enticing, and that's why I've not been interfering with the presenters as they make their presentations. So we'll have the final respondent from Professor Paul Morris Siaga. Then after that, I'll allow for a brief session for responses to questions and comments that have been made either through Facebook or through the chat section. Then I'll ultimately hand over to Professor Ambreena Manji to also make brief remarks on the general responses that have been made to our presentation. Then after that, we'll be able to bring the event to an end. Professor Paul Morris Siaga holds postgraduate degrees in land economics from the University of Nairobi. He worked in the academia between 1975 and the year 2021, rising through the ranks from lecturer to professor of land economics in the Department of Real Estate and Construction Management at the University of Nairobi. He was visiting professor at the University of Pretoria, University of Newcastle, and University of Dortmund, and external examiner in several universities that conduct real estate programs. Professor Paul Siaga has consulted and published widely in the area of land economics and related issues. He is the author of the book Real Estate Valuation, published by University of Nairobi Press in 1994, the co-author of Building Maintenance Management, published by Intermediate Technologies in the year 1987, and U Management and Agency in the Urban Real Property Market in Kenya, published by Shekhar in the year 1999. His other publications include The Impact of Compulsory Land Acquisition on Displaced Households, The Case of Third Nairobi Water Supply, Land Ownership and Use in Kenya, Policy Prescription from an Inequality Perspective, published in 2006, Land Tenure in Slum Upgrading Projects, published in 2011, Public Land Historical Injustices and the New Constitution, published in 2015. Professor Siaga was technical advisor for the formulation of housing policy for Kenya in the year 2004. He was a technical advisor together with the late Professor Okoth Ogendo on the formulation of the National Land Policy for Kenya in 2009, and technical advisor for the Civil Society Urban Development Program 2009 to 2013. Currently, Professor Siaga is the principal consultant at Siaga and Associates Limited, a multidisciplinary research and development consulting firm dealing with real estate and the built environment. He is also updating his 3 books for new editions to be published online. Welcome, Professor Siaga.
Thank you. Am I being heard?
Yes, I can hear you very well, Prof.
Thank you. I have had a chance to read the...
Carry on, Prof. We can hear you very well.
Okay. If I'm being heard now, I can start. I have had a chance to read the book under discussion, and I was very much impressed with the issues raised, which are both contemporary and indeed, even those who are working today in cases of compulsory land acquisition meet the issues of compensation in terms of whether we are only going to deal with the physical assets or are we going to deal with the soft concerns, such as, for instance, the networks that people have in places where they live. How would you do, or how would you compensate for that? But in Professor Manji's book, she has raised a number of important concerns. For instance, she has questioned whether there's a difference between land management and land administration, because both the Constitution and both the Land Act and the rest use both. They're saying land management and administration. And essentially, land management is supposed to be the one that is laying the policies and regulations that will govern how land is going to be used. And when you get to the administrative part of it, then that is actually the implementation. That is the doing of what it is supposed to be. And that is how the problems came in, that in the Constitution, we said that National Land Commission is going to manage land. And this is what brings in the issue. We should have said manage and administer. Then it would mean after making the recommendations, it could then go down and, for instance, administer or execute. But that is again an issue for another day, and that's what brought the many problems that we had in the past. The book also questions whether we are dealing with legal reforms or we are dealing with land reforms. Essentially, again, we must question the historical development and the sphere in which all this has been done. Ideally, the land policy should have indicated the areas of reforms that are expected. And when you look at those areas of reforms that were indicated, they were institutional, they were legal. And in the legal, it said we should rationalize the many land laws and bring them closer and easier to access. The institutional came in the issue of the national land policy, the issue of the National Land Commission. And the idea here at that particular time is that Kenyans were very angry with the way land was being accessed, and that you would find that you go and play golf, and at the end of playing golf, you would have a letter of allotment that you've already been given a given piece of land. However, again, I regret, because I was in that process all through and through, that we concentrated more on public land rather than all the land. And this is again how in the enactment of the National Land Commission, its role on private land again came in and was lost because we were angry and we thought that there was more public land to be dealt with, which actually was not there other than what is now that was called trust land. So again, we would see it in the light that the reforms that were expected were again mentioned within the national land policy. And therefore, it was thought that when you put the institution right, you've removed everything else from the centralized national government, and we put it into an independent body, we would then be moving in the right direction. But with that, then we had to tackle the laws that were governing land. And there are about the 75 odd pieces of legislation that were governing land. Again, the national land policy therefore need to be blamed or questioned that it did not go far to see that it was not just the legal and the institutional reforms that were required, but that we needed to look at other issues. The book questions about the use of the term historical land injustice. Why historical? The land injustices between me and you are continuing. For instance, the issues of what we call involuntary resettlement that are going on, like for instance, the oil in Lake Turkana, like for instance, the Aror Dam and the likes of them. We are displacing people involuntarily without them accepting. Now, again, that is because the law allows it, but in the process of restituting those fellows, do we really do it? Do we really do a total restitution? The IFC and the World Bank, of course, are even questioning us and saying we are not compensating people. We are only compensating them for the physical assets, but the soft assets, like for instance, the social networking, for instance, the merry-go-rounds, for instance, the churches that these fellows have been going to and meeting their friends. How do we compensate for those, and that we are not taking account of those, and that those should be taken into account? That is what goes on with what Professor Manji is saying, that surely, what about this other cultural? What about these social concerns? What about the psychological torture that these fellows who are being displaced have gone through? And so in that context, it will not just about the historical, but it will be the contemporary. And that's why I agree with her that the issue is not necessarily historical land injustices, but we should be talking about land injustices. Now, as to the cutoff dates that we have being 1895 and then coming to 210, again, the debate was who would be responsible for restitution. We are aware that, in fact, particularly with respect to the cost, the dispossession took place very early during the Arab invasion, And when we came to the year 1908, when the British colonial administration was there, we asked the people to bring their documents to show that they own the land. The natives had nothing. They had no idea that, in fact, the Arabs already surveyed the land and already had the certificates, and therefore they would present them. And anybody else who therefore did not have any documentation to present lost the land. And that is how the squatter system at the coast is taking place, which then means we would have gone further to the 16th and 17th century, but we questioned who would then be responsible. We said the British government, when it came in and took the land, handed over both assets and liabilities to the Kenya government. And that is the one that we could go to and ask for ensuring that restitution is carried out. That is how, again, the history came in. Again, the cutoff date of 210 came in because we thought that this was going to work as a program, such that you carry it out and finish what was on before. And now, hopefully, continue to manage appropriately what is coming on thereafter. Otherwise, again, land injustices are past and present and would continue, and therefore there needed to be a system properly laid down to look into this. I agree with the chair of the National Commission that they have been attempting, but that is tinkling, because one would have thought that we would have set up, for instance, a tribunal whose work for those first 5 years would be basically dealing with that. As the chairman now puts it, he's doing this among his other duties because there's no dedicated institution or department that would be dealing with this. And in that sense, then, these historical land injustices are going to be with us for the next century also. In terms of restitution, and that I think is where it is most important in this debate, what method of restitution or what system of restitution would you have in place? The Truth and Justice Commission said that besides any other compensation that you would give, please, would you also appease the people's mind? Would you, for instance, apologize to them? That is, if apology would have sense or would have meaning to them. But again, we are saying, it is not simply saying, yes, your land was taken away from you. We are giving you back the land, if the land is available anyway, and that is sufficient. No, what is being said, as I said, total compensation, is to deal with the trauma through which these fellows have gone through. In other cases, we normally have to do counseling. In other cases, a host of other things have to be done to right the wrongs, to bring this fellow to a mind that can begin to function. But in the case of these land injustices, we don't seem to be doing very much. The land injustices are going on. There is the oil in Turkana. There are many other things like the Aror Dam. There are many other things like the, and all those other things are continuing, which are issues of injustices because you are displacing these people from their neighborhoods and therefore making them either go to live wherever they want or they don't want. And when I did an assessment of the impact of the displacement of the people in Murang'a for the third Nairobi water supply project, half of them died. They were used to that good soil. They had to go and look for pieces of land elsewhere. They had lost their networks. They lost those to whom they were used to it. And within the span of about 3 years, half of those fellows had already left the world. Now, that is how bad this thing has to be. And this is why issues of resettling those who are displaced becomes very important, and one has to question in what way would you do a resettlement that still keeps these fellows with their contacts, a resettlement that indeed improves their lives so that their lives are better off than probably what it was before. Now, this therefore become the debates that I think are on and should continue. And the author therefore should not tire up, but continue raising these other issues so that at the end of the day, when you are going to do restitution, the restitution then is going to be seen to be complete. The restitution is going to be seen to be meaningful. The restitution is going to be seen not merely as window dressing, but taking into account the livelihood, taking into account the psychological mentorship and all other things that would go with this other thing. I think with those, I want to stop and let therefore the debate continue. But otherwise, I thank Professor Manji for that incisive questioning, because we should not stop questioning because we say that this is how it has been done for the last century. No, we need innovators as well as we need inventors. Thank you very much.
Thank you very much, Prof. Siaga. You raised an important point. And I don't know whether this would make attempts towards the solution of land injustices easier or more difficult. You indicate that historical land injustices did not begin in 1895. So we need to go past that. And of course, as Professor Ambreena Manji had also indicated, they didn't end in 2010, they are ongoing. And I think for us to be able to deal with the question of land injustices, we must start by conceptualizing the problem in a true manner. Because when you don't conceptualize a problem in its truest form, then no matter how much effort you put towards its resolution, usually there would be people who would come up with other claims because they would not have been taken care of. So it means that for us to deal with the land question then in a meaningful manner, then we must look at it from a realistic and from a wholesome point of view. We were expecting to have a presentation by Ms. Faith Alube, who's the first Chief Executive Officer of Kenya Land Alliance, and she was actually part of the meeting earlier on. But other engagements have made it impossible for her to take part as at this point in time. We received questions and comments through the chat section and on Facebook. So before I hand over to Professor Ambreena Manji to make her comments in response to the various respondents, I would invite Mr. Otachi, that's the chair of the National Land Commission, to respond to two particular questions. There was the question of whether the decisions of the National Land Commission are publicly accessible and whether they are reported. And there was also the question of what's the form of the hearing of the claims. Is it purely administrative or quasi-judicial? Chair, if you're still in, you could take those two. Chair, I think you're muted.
Can you hear me? Can you hear me now?
Yes, I can hear you, Prof.
Okay,
Yes.
sorry. I had a bit of a challenge in meeting. Okay, the first question I think I was actually responded to by Mr. Edmund Gishuru of the HLI Secretariat. NLC decisions are not. It's actually on the chart. The decisions are not reported, but summarized versions are available in the Kenya Gazette. The first historical land injustice decisions were gazetted on 1st March 2019. But maybe just to add quickly that we are working towards a sort of a digest on that, so that is in progress. The other question I'd actually responded to earlier about, I think there was a question by Professor Siaga. I think I responded to it earlier. But if I may, I think there are two other questions. Would you allow me to answer the two other questions so that then I can exit?
That should be okay. That should be okay, Chair.
All right. So the other two questions that I've seen on the chat, there are two questions I think I would answer together. There's a question by Mr. Mukabi Arnold, who says there's too much procedure involved in legal dispossession. Could that be the reason for NLC has not managed to solve half the claims? Maybe it's time we admit the law is the hindrance. And a related question is by Isaac Maina from Moi University, who gives an instance of a case where after independence, government officials illegally acquired land, subdivided, sold, and so on and so forth, a repeated cycle. And he was asking a question about the solution to that. Now, let me just answer this broadly that, first of all, as pointed out by Mukabi, legal dispossession of land is not an easy process. We all appreciate that land matters are very, very emotive. And anyone here who has any small parcel of land anywhere, if any attempt were made legally or otherwise to dispossess you of that land, it will be a hard-fought, process. So that is the reality of matters. That dispossession of land is not easy, and that is partly why, as I said earlier, when the remedy that is recommended by NLC is restitution, then there are chances that it will be quite a process implementing that if the land is already in the hands of another party. And then again, to add on to the question by Mr. Maina of Moi University, there are no obvious easy answers to certain questions on matters land. And that is why there are matters that are ordinarily handled by the courts. Most of the disputes are handled by the courts. The commission was mandated to deal specifically with historical land injustices, but also with review of grants and dispositions. And that mandate again was time bound. So there are various entities that deal with that mandate of land disputes. Now, then the last question I want to deal with is a very specific issue here from Mr. Wambola. He asks a question about the Yala Swamp that falls in Siaya and Busia counties, and the notice of intention to allocate the parcel to a private investor. Now, in summary, there have been many queries around this, and indeed, as he points out, yes, there have been objections that have been lodged with us. There was a court case that was filed that stopped the process. The matter has also been the subject of an inquiry by National Assembly, where I have appeared. But the short answer to all this is that there is a procedure in the Land Act of a 30-day notice. Once the county government or national government intends to allocate land, we issue a 30-day notice. And the purpose of that notice is to receive those objections and deal with those objections. Now, because of the court case, that process was stalled, but that was recently resolved in court, and we intend now to have a public hearing in Siaya at the beginning, I think mid of June, as the law contemplates, and then all the issues that you pointed out, whether it's community land or public land, what other interests there are, what concerns there are by the community, then they are addressed at that public hearing. So we'll be having a public hearing from around, I think, 13th, 14th of June. So I think I've answered all the questions addressed to me. I don't know if there's any other. I wanted to be able to answer all of them, and then I can, with your permission, exit.
Chair, I think that's all that was posted for you. And thank you very much for, again, sparing time for this event. We really appreciate and we hope for further collaboration moving forward.
Thank you. Thank you very much.
Thank you. At this point in time, then I'll invite Professor Ambreena Manji to make her responses to the responses by the respondents, and to try keep it brief so that we don't keep people too long. Over to you, Prof.
Can you hear me?
Yes, we can hear you, Prof.
Perfect, thank you. Thank you so much to all three of the respondents for taking the time to make what I think are exceptionally thoughtful remarks. I just want to say one or two things to try to draw together the different comments that have been made. I mean, from my point of view, it was very interesting indeed to hear from the chair of the National Land Commission to actually have an insight into the work of the Commission, to understand some of its concerns and to get an insight into its own understanding of its mandate. I think that was exceptionally informative. And connected to that, to hear Professor Siaga talk about the difficult questions within which we are faced when we talk about restitution. What is it? I mean, this is the link for me between all three sets of comments is, what is it that we are restituting? When we talk about restitution, land restitution, what is it that we are restituting? And all three respondents, I think, recognized and expressed that what is being restituted is not simply material, it's not simply the land, but it's fundamentally about social relations. So Professor Some put this beautifully when she described land as an expression of social relations, and holding on to that idea, I think, is extremely valuable for us. I just want to say as well that we have with us on the call students, law students, land law and property law students from Kabarak, from Moi University, from University of Nairobi. And for those students from those three law schools, I would want to say that what you saw this afternoon on this call, and I hope you enjoyed the discussions, is what happens when colleagues sit down together and think with generosity about each other's ideas and about each other's perspectives. So from my point of view, for example, the comments of Professor Some, even as she was making them, I recognized that what she was doing here for me was literally setting out a research agenda for me. So she had read my work, and then she had connected it, made connections with her own reading, her own concerns, her own interests, and she was recognizing what the work I've done, but also asking me to take it further, to make further connections. And that act of setting out a research agenda is such a powerful thing when colleagues do it together. It's why this idea of a Meet the Author series is an excellent initiative by Kabarak Law School. And all my colleagues this afternoon have done this. Professor Siaga, Chair, have done this by providing their own perspective on their work, giving concrete examples of cases with which they are faced or questions with which they are faced, and connecting it to the wider conceptual concerns that I have in the book. And what that has provoked this afternoon, I see it in the chat, is a lot of questions from each of you about how we might deal with historical land injustice. Concretely, what are some of the, if you like, solutions to this problem, which we all acknowledge. I suppose what I was trying to do this afternoon was to encourage us to ask the right questions, to try to identify what the problem is in the first place before we can think well about what some of the solutions might be. I won't have time to address all of your questions in this session, but what I will do is take note of them, and then if I can write to you individually with some thoughts and insights, I hope that will be helpful to you. I found this session very useful indeed. I thank the respondents again, and thank you very much, Omola Joseph, for your wonderful work of moderating, and I'll hand back over to you.
Thank you very much, Prof. Ambreena. Indeed, it was a great pleasure to have you be the author for our inaugural edition of the Meet the Author series. I'm sure we've learned a lot, and we hope to continue having these conversations moving forward. At this point in time, and again, my apologies that we've really overshot the schedule, but we're now coming to an end. Allow me to invite my colleague, Dr. John Wamwara. Dr. John Wamwara is the Dean, School of Law, Moi University in Eldoret. He'll make the closing remarks, then we can call it a day. Welcome, Dr. Wamwara. Dr. Wamwara, you could be muted. Unmute. Dr. Wamwara, I can actually see you. Are you okay? Okay.
Can you hear me now?
Go ahead. Yes, I can hear you.
Good afternoon, everyone. I think when brilliant minds come together, time it becomes an enemy, and that's what has happened today. Every one of you has added to our cup of knowledge. Let me start by saying thank you to Professor Manji. I really do hope this is the beginning of a long conversation, and that you being the first author that we have read and discussed her work. I think we stayed with this network. I want to thank the panelists as well, and the three schools, the four schools, including the chairship of Kabarak University Law School. Thank you very much. Let me hope that this is the beginning of a concerted effort to ensure that which we write in academia influences the policies that our government makes. And today was particularly very encouraging because almost every stakeholder in the land sector was here, either as a discussant of the book or contributors to the work. I really hope that that becomes what we will do, that we have selected days of the month when we let academia engage policymakers. And thank you very much, Joseph, for making this happen. And let us by the way, on the land issue, I just want to finish by saying this, that time and space define all of us. And you can never define yourself without a sense of home. And that when you talk about, particularly when you remember what happened with Kenya's post-election violence, people who were caught up in 2007 and 8, people were caught up in whatever places of the world. Their cry was, please, most of them, their cry was, please help facilitate our return home. And land is what defines home. And that's why, even as we talk about historical injustices, I want to ask that we keep asking ourselves, especially when we think about law as the vehicle for justice. Sometimes it fails, just like Professor may say. Sometimes law fails as a vehicle for realizing justice. Otherwise, I want to say thank you very much for everyone. We wish you well, and we look forward to the next series. Thank you very much, Professor Osogo. Professor Zambani. Thank you very much, Bwana Omolo, and we look forward to the next one. Asante sana. Thank you.
Thank you very much, Dr. Wamwara. Allow me this late in the day to once again thank everybody on behalf of Kabarak Law School, Cardiff Law and Global Justice, Moi University School of Law, and University of Nairobi School of Law Campus for having spared time to be with us this afternoon. We know Friday usually is a difficult day when people tend to travel in Kenya, mainly out of town. So we don't take for granted the fact that you sacrificed that chance to be able to take part in our event today. As I mentioned at the beginning of the event, this is the first edition of the Meet the Author series. We'll be having many more. So expect us to reach out to you so that we can further the collaborations and the conversations. In the meantime, I wish you all the best this Friday afternoon, and let the conversation continue on the social media platform. Thank you very much. Kwaherini. Ended.